Okay, then let's have Leo Specht first, okay? Let's have Leo Specht present. Thank you.
Let me repeat that I'm thankful and great that you have invited me to this conference, and I'm very sorry that I couldn't join you for several reasons. I hope very much that we will have a second and third and fourth and so on conference, and that I will be able to go to Turin and to be there in person. I do not want to speak here about Brics in any academic terms because I would not find it interesting or helpful. I would like to speak about Brics from the point of view that the world needs alternatives to the neoliberal mainstream and to the hegemonic arrangements which are in one way or another derivatives of institutional arrangements copied from those prevailing in the North Atlantic basin. So my first approach to Brics would be to ask whether it is just another trade arrangement between states and whether this arrangement wants to just get a larger piece of the cake in terms of distributing markets and resources. If this is the case, then I would find it not very interesting to engage with Brics as an institutional arrangement. I believe it is not the case, but not because of the intentions of the elites in the countries which are governing the various member states of Brics, but because of the way societies and economies in most of the countries which are now members of the Brics are organized and are working. And I believe that these dynamics, if carefully studied and not viewed from the point of view of are they normal or not normal, and can they be normalized or not normalized in the sense of the prevailing institutional arrangements, give us some field for experimentation with new institutional arrangements and to work in a different way than the mainstream and the orthodoxy of the mainstream proposes. So my interest in a sustained and ongoing study of the law and the economies of member states of Brics would be to better understand their institutional arrangements and to find out what is different from the ones which are the prevailing ones in the world and which have, through one or the other attempt, been elements of colonializing these economies, societies, and the elites in these Brics countries. And the point which makes me think about this as an interesting exercise, which I find, for example, in the Constitution of the Republic of South Africa, is the multitude of arrangements, the multitudes of traditions which exist in these countries and very often differ from the prevailing institutional arrangements as we know them. This is something which is important and has been important in the context of the anti-colonial development of many of these countries. But it is also today important in the sense that they mark lines of disruption and of difference to those which we know in Europe and in the Anglo-American world. And in addition, they very often coincide with the way advanced and organized parts in these countries, in their economies, in their societies, and the less organized are relating to each other. And the energy and the dynamics of this relationship, which you might also describe in terms of the more advanced centers and the less advanced peripheries in these countries, are the material which in studying and trying to understand, and in trying not to look at through the lens of normalization, might give us some food for thinking, and most important, some material for experimentation. So I am interested in the many legal arrangements and institutional arrangements in the productive and distributional practices of the periphery in these countries, which I consider to be much more interesting than the shallow attempts of elites and the results of their attempts to copy what is going on in the advanced parts of the world. I am interested in the modes of enforcement of such other arrangements and what we might be able to learn and take from this. As a transnational structure, Brics could be also interesting from the point of view of breaking the dictatorship of the dollar and the close to religious orthodoxy of finance, which is crippling the world. So it would be interesting to see whether on the levels of governance structures of Brics, there are already institutional arrangements and approaches which go beyond the traditional ideas of finance and financial services and change the relationship between the material world of economies and societies and finance. I'm very skeptical about this if I look at the current arrangements, but the cultural mix which is present and represented in these Brics countries will or should give some ground for developing something new. This would be something very interesting, and the consequences of this would be very interesting. And I think if we are serious about studying the Brics countries from the point of view of alternatives and alternative visions for the world, then this would be an exercise which should also be programmatic and not simply academic. And in this sense, I am very skeptical about any engagement with so-called transplants. And I think from the point of view of rejecting this colonializing approach of legal and economic transplants. The realities of Brics would be interesting to be studied in terms of the failure of such attempts. So to sum up and not to take too much time, your initiative is interesting for me as an attempt to study in a programmatic sense, which means preparing for practical interventions, material which differs from the material we are accustomed to in the advanced societies and economies of Europe and the Anglo-American world, for the purpose of programmatically setting out many different, not in the sense of a blueprint, not in the sense of a model, many different ways of organizing our societies anew. Thank you.
Okay, so it's an incredible honor to be asked by Ugo to reply to Professor Unger's command performance that we all witnessed this morning, not only because, of course, it was a typically bravura performance by Professor Unger, but in fact, I think even for him, an especially incredible and powerful performance. And it's also an honor for me because I was a student of Professor Unger's many years ago. He was one of my doctoral advisors, and more importantly, I'm part of an emerging movement in American law called Law and Political Economy that bears a strong imprint of Professor Unger's influence. So Law and Political Economy, Professor Unger's work, and the Brics project that's been presented today are the three things I want to talk about together at Professor Mattei's invitation, that we try to integrate Professor Unger's talk, Law and Political Economy, and the Brics project. So I want to say a few words first about how I conceive of law and political economy and its relationship to Professor Unger's work, and then offer some critical remarks on aspects of Professor Unger's work and, as evidenced in part this morning, related a bit to some of the presentations we had, and then offer some constructive alternatives to end, if that makes any sense as a trajectory. So, law and political economy, as I understand it, is an emerging movement in the United States and elsewhere, Europe, BRICS plus countries, which is interested in three topics: political economy, law, and the most important, and. The and is not the interaction of law and political economy, it is the interrelation of law and political economy. It is how political economy mutually constitutes and shapes law, and law mutually constitutes and shapes political economy. The idea is you cannot conceive of PE without L, you cannot conceive L without PE, but of course to do that you must first conceive each and then see how they relate to each other. This conception of law and political economy and its urgency has become important in the United States only recently, maybe 2008 financial crisis, the 2016 election. But it has to be noted that in 1996, Professor Unger, in What Should Legal Analysis Become?, had already identified law and political economy as the central disciplines of social thought. In his words, the twin disciplines of institutional imagination. In this, as in many other things, he was far ahead of the rest of us. Now notice, he called them the twin disciplines of institutional imagination, not institutional analysis. And the difference between those two formulations I'll return to in the critical components of my remarks with respect to the relationship of how I understand LPE and Professor Unger's work. Professor Unger's work was deeply formative for many of us who are now at the heart of the LPE movement. And speaking for me in particular, especially formative, was his 1975 book, Knowledge and Politics. Knowledge and Politics was an incredibly brave and pioneering effort to understand the deep structure of modern thought, understood as liberalism. However, like many pioneering works, it faltered at crucial steps, and in 1976, Professor Unger himself, in a very famous afterword, gave up the project of a deep structural analysis of liberalism, renounced the project and called himself a super liberal. An echo of this was found in his 1987 three-volume magnum opus Politics, where he said, and I quote, "We have to find a way to think generally about the history of production and power without having to rely on concepts like capitalism." Now, my own view is that it is simply impossible to analyze law without understanding the structure of liberal thought, what Ugo Mattei calls mentalité, and it's impossible to understand political economy without understanding the institutional structure of capitalism. The discursive structure of liberalism and the institutional structure of capitalism are the sine qua non of understanding modernity, of understanding our societies, and of understanding law and political economy in modernity. And so, with this, I want to make a bridge between this and my more critical components with a few quotes from Professor Unger, which I think illustrate precisely the predicament we are in with his trademark exactitude. So, in 2017 essay, The Universal History of Legal Thought, Professor Unger has the following quote, which illustrates to my mind quite perfectly the utter sterility, banality of trying to understand L without PE, of trying to understand the law of any country today without embedding it in an account of its political economy. He says, and I quote, "Suppose that as an outsider to society, coming from a place far away from it in time and space, and uninformed of its history and particulars, you can decipher its language and gain access to all its texts of law and legal doctrine, but to none other. You would be unable to infer from these sources the actual organization of the society and of the economy." Bingo. Precisely so. The study of law severed from the social structures of political economy is a sterile exercise in mindless empiricism and formalism and scribing. It's just not a serious enterprise. Now, how do we study political economy? I think the study of political economy without the study of capitalism is equally barren. And here I want to situate my understanding of law and political economy and contrast it with what I understand to be Professor Unger's as follows. Political economy is standardly understood to be one of three approaches. One, which is a mainstream apologetic approach, tries to analyze politics through the lens of economics. The lenses of neoclassical economics, rational economic actors maximizing self-interest as utility. The lenses developed by neoclassical economics for the study of the markets are now applied to the government. Okay, that's one mode. That's a new approach. It started with the Virginia School in the 60s and 70s, political economy. An alternative, more heterodox approach is the reverse. It tries to use the lenses of concepts developed for the analysis of politics, coercion, power, and tries to show their presence in the economy, as against the economics, which says it's all about market choice and competition. So now we have the reverse move. Politics is used to understand economics. And then there's a third approach which tries to understand the two back and forth integrated. Politics is conceived abstractly, economics is conceived abstractly, and then the two are analyzed in their back and forth. I think all of these approaches are ahistorical, transhistorical, barren, and doomed to sterility. The right approach, in my view, starts with the fundamental insight of Karl Marx, which is that we are not trying to understand something called political economy, but we are trying to understand something called capital. Marx showed how the classical political economy of Adam Smith and David Ricardo and Thomas Malthus and John Mill naturalized a historically specific emergent phenomenon. What they call the invisible hand resulting from human nature was, Marx showed, a historically unique, specific, distinctive mode of social life called capitalism, which resulted from subjecting all economic agents to the pressures of market dependence through an accidental resolution of a class conflict in feudal England. It was an accidental emergence of a new phenomenon in human history. It was not foreordained, but once it was backed into, It unleashed, first on England, then on Europe and the rest of the world, a set of systematic imperatives and compulsions resulting from subjecting everyone to the market, not as an opportunity, but as an imperative. This systematic institutionalization, it's a socio-political institutionalization through centuries of enclosures and various laws and projects consolidating a 17th century initial emergence, which institutes and subjects all people, their needs and powers, all relations, the earth, to the systematic compulsion of expanding exchange value for the sake of expanding exchange value for the sake of expanding exchange value. That's capital. Capital is a logic driven by a relation. We have to understand the structure of the capitalist relation to understand the logic and its exploitative, destabilizing, alienating, colonizing, ecologically catastrophizing effects. That's the object of analysis of law and political economy. Political economy did not exist as a discipline in the history of human thought until capitalism first emerged. To speak of political economy in the absence of capitalism is to speak of shadows flickering on a cave. It's not the object of analysis. Now, this risks saying things with some concreteness and specificity, and I think that's fine. One can be wrong. What one cannot do is be vague and evasive. Professor Unger has a brilliant Latin phrase he says, strikes many people today, noli me tangere, do not touch me. We should not go to the world with this attitude, I agree. Nor should we articulate thoughts with this attitude of saying things at a level of abstraction or evasion which makes it impossible to ever pin anything down. And so here I want to get to some more critical remarks, both about some of our discussion today and about Professor Unger's otherwise quite remarkable and inspiring bravura performance. One, I simply don't think it makes any sense to be talking about law in the abstraction of political economy, and we then have to specify what we mean by law as a system of social relations. And so here is a fundamental point. To conceptualize PE and law, to conceptualize capitalism, to conceptualize modern law, you need a theory of social structure. Professor Unger has said precisely again, in 2017, we now lack a reliable way of understanding how the real structure of society gets made and remade in history. We have been left with no reliable way of thinking about how structure, in particular the institutional structure of society, changes, and consequently no developed account of what it is. Precisely. And you cannot have an account of structure if you do not allow yourself to specify with concrete exactitude what you mean by capital, what you mean by rights, what you mean by property, what you mean by law. But legal scholars have an occupational hazard. They are simply unable to articulate with any specificity any concept, because then they feel they are wedded to it forever and ever in a mode of theological disquisition. This is pre-scientific and unserious. You have to specify concepts within a framework of explanation and evaluation, allowing yourself to be committed to ideas that may change. This is not a theological inquiry about what the essence of the market is or the essence of property or contracts. We are developing concepts to understand our world. So now allow me two illustrations and I'll stop. The first illustration. Professor Unger says absolute property rights are only to be at the margin of a revised political economy, although they can be there, unlike the place they have in the hold of liberal thought from Blackstone on. The problem is this: there is no such thing as an absolute property right. I'm not saying we shouldn't have them, they're not good, they're bad, they're right, they're wrong. They don't exist. They don't exist because property is a social relation. It is nothing else. Rights are a social relation. Rights are not things you have, like eyesight. They are not needs you have, like hunger. Rights are claims of one against another. You have no rights on a desert island. Rights come into existence in the presence of others. Rights are social relations. Property is a system of social relations. we can understand the architecture of that system as a system of use rights, exclusion rights, transfer powers, and expropriation immunities in various packages. What we cannot do is think that any package could be absolute, because that's an impossibility. It's an impossibility that anyone could have unfettered entitlements with respect to any resource, if for no other reason that those entitlements would come into conflict with the entitlements of another owner of another resource. Absolute property rights are the chimera, the cri de coeur of liberals who believe individuals exist outside of society, outside of social relations. They do not. Now, the same analysis of law that can be applied to rights as social relations to unpack the distinctive architecture of property rights, contract rights, criminal law, constitutional law, tort rights, on the micro level has to be done on the macro level to understand capital. Capital is a social relation of generalized market dependence or generalized commodity production, which subjects everyone to market dependence for their basic existence, and will necessarily ravel into a vertical relation of class exploitation and a horizontal relation of generalized insecurity. And this social relation explains, like no other account, the trajectory of modern productivity, population dynamics, technological dynamism, and ecological catastrophe. If we don't want to understand these things, then we don't have to speak of capital. But if we want to understand these things for the sake of transforming them, we have to speak of capital. And once you speak of capital in this way, and I should note, this has zero to do with what classical Marxism says. Zero. This has nothing to do with classical Marxism at all. Once we understand capitalism this way, we understand that the system of capital operates by separating people from any decommodified, non-commodified access to the means of life. The means of life, not the means of production, is the central unit in this account of capital. And the central takeaway is the following. Your freedom in the market is a direct function of your freedom from the market. We are only free in the market to the extent that we are free from the market. And the project of transformation has to be from generalized markets to socialized markets, from markets as imperative to markets as opportunity, from markets as disembedded to markets as embedded. Markets are themselves a social relation, but they are a social relation that has threatened to become out of social control. And this, I believe, is the fundamental transformative agenda that we should bring our critical and practical abilities to bear. Thank you.
Thank you. Professor Talha, thanks for your brilliant speech. And next, we have Professor Lidia online. Yeah. Professor Lidia, can you hear me?
Oh,
okay.
Thank you. Slow.
Okay.
Can you hear me?
Yeah, the microphone is yours.
Great. Great. Dear colleagues, dear ladies and gentlemen, I'm very glad to meet you online, and I'm really sorry that I couldn't come today. Here, I represent a very special organization. I represent here the Russian Private Law Research Center, of which I am the head. Our Private Law Research Center was the creator of the Russian Civil Code and continues to develop law drafts that amend the code. In addition, our research center develops the doctrine of Russian private law in cooperation with the Supreme Court of Russia and various Russian universities. So let me divide my speech into three parts. First of all, I would like to speak a few words about the Russian legal system, especially about the private law, of course. After that, let me make suggestions about the prospects of the Brics and its impact on the legal systems. And finally, I would also like to say a few words about the future Brics Law Academy. So, Russia has been always strongly influenced by Western philosophical thought and Western legal systems. Both during the period of Tsarism, the Russian Empire, and the Soviet period, and even more so now. For this reason, it can be argued that, unlike China and other countries, the Russian legal system is closest to the European legal systems, in fact, closest to the German one. I mean, the similarity of the matrices of concepts and mechanisms, as well as the similarity of the basic ideas that ensure a balance between private interests and the interest of society. My words about the similarity of the Russian legal system in its current state to the legal systems of European countries should be attributed to what we call written law, the legislation and the doctrine. The peculiarity of Russian law is that written law can differ enormously from the real legal life. I have quite a few examples of this. Recently, cases of expropriation of business assets have become more frequent. The reason for that is violations committed during the privatization of Soviet state property in the early 1990s. The Russian Civil Code protects these old deals by a limitation period and does not allow for the possibility of vindication or restitution due to the expiration of the limitation period. However, the Prosecutor General's office applies to the courts with claims for restitution and vindication, and the courts satisfy these claims. It is especially surprising that assets are being withdrawn from new bona fide purchasers. Alas, such disregard for one's own written law is not a rare phenomenon in the entire history of Russian law. Sorry, I'm not sure that all the forum participants will understand me, but this characteristic of the Russian legal system in our country is described by the Russian proverb, the law is like a drawbar. Wherever you turn it, that's where it goes. In English, it is there is a similar proverb. Every law has its loophole. So I sincerely love Russian legislation. Also, I still see many disadvantages in it. I know how Russian legislation was built and how much it took from European legal tradition. But at the same time, I know how this excellent and modern toolkit can remain unused or be misused. I hasten to assure you, dear colleagues, the report on Russian law presented today is a great and detailed report, and we must thank its authors for their hard work, really hard work. However, it seems to me that some aspects in this report are shown through the prism of propaganda publications. In a couple of places, this report contains a number of exaggerations. Look at this thesis, page 40. Russia's participation in Brics is best viewed as a deliberate counter thrust against the unipolar order consolidated after 1991. Yes and no. Indeed, Brics is being presented as an alternative to the old order. But how honest are such words? I'm not sure. It seems that when political leaders say now that Brics is an alternative to the old order, they are giving a little wishful thinking. During this time, we have managed to see situational solutions that demonstrate rather tactical moves and the search for mutually beneficial cooperation in the context of the current situation. Thinking about it, I'm not sure that the general idea can be built on denial. You can't just deny the old world and work together only on that basis. And so far, I don't see a positive idea in a wide information field. A new positive idea is needed for unification. What is this idea? Protection of sovereign states, regardless of their political regimes? I don't know. Protecting individuals as a guarantee of progress? Maybe, but I don't know. No, I have been watching what is happening in connection with Brics for a long time, and so far I have not seen a new positive idea. But maybe I am a bad observer, maybe. One more thing. It is expected that this autumn in Rio de Janeiro, we will sign an agreement on the establishment of arbitration for the Brics countries. This arbitration is almost set up, and almost everything is ready to start its work. I see this as an instrumental approach. If there is a need to build trade relations with the Brics countries, then the need to create Brics arbitration also will be realized. Mind you, the instrumental applied approach is visible in everything. This is neither good nor bad. It just allows the world to survive and evolve. And we don't know what this process eventually will lead to in 20 or 50 years. But we cannot stop this process just because an important philosophical idea has not been summed up. Moreover, we must continue to work on building Brics, if only because this cooperation is beneficial right now. One of the benefits is that we get to know our legal systems better. Another benefit may be that we can find a great unifying philosophical idea. I would like this idea to be based on humanistic principles. Russian legal scholars believe in humanistic principles. We respect the primacy of individual interests that drive progress and economic development. We see how sometimes these interests are violated, but we still believe in their priority. And finally, of course, I consider that initiative to create the Brics Law Academy to be extremely important. At the Academy of Law, it will be possible to gain knowledge about the legal systems of all Brics countries, and it will be possible to enrich the knowledge of law principles. Moreover, it can be a platform for searching for a joint philosophical and law idea. This task is within the power of the future academy. I'm ready to propose a number of steps to create an academy. And first of all, we can use the contacts with a large number of partners, including the partners in the countries of the former USSR. I am ready to invite all my partners and invite them to send students and law professors to study at the new academy. And I'm ready to talk to some Russian law firms about finding ways to financially support the academy. I believe that law firms could also send their employees to the academy for training. And of course, I'm ready to provide a number of speakers on Russian law if the academy holds classes on comparative law. So if we have some kind of roadmap, we can move step by step, and it will be a great process with great results. I know. In conclusion, let me thank you for your attention. I'm really sorry that I couldn't come today, but I hope that we all will stay in touch. Thank you very much. Thank you.
Thank you, Professor Lidia, and thank you for the support from the Council of the Private Law Research Center, and I sincerely invite you and your colleague to attend the second Brics Plus Law Forum in China next year. So thank you very much. And our next speaker is the old friend of IUC and both IUC and me, Avi.
This is a little bit of an encore, so only the highlights. But I'll focus more on Brics than anything else. And the idea which we are starting to discuss of the alternatives that Professor Specht also spoke about. Can I be seen? Okay. Yeah. That Professor Specht also spoke about, which are is Brics not a competitor but an alternative? What should that alternative look like, etc.? And I want to start by expressing that I don't think we are proposing, in my opinion at least, a new alternative. I think we are trying to study something which already exists, to some extent or the other. In one way, we had the end of history. in the early 90s. The famous, history has ended, and Professor Ugo has written about the unilateralism in a comparative international law essay. However, history has a way of kicking back, and history is, of course, certainly back with a bang. All kinds of history, are we in pre-World War I or pre-World War II, ancient and modern grievances, justifications for war based on Bible or Quran or whatever it is. So history is certainly back. But in this, does international law, or perhaps a better way to say it, does the international rules-based order, which was built by and then expanded after 1991 to be almost universal, and the underpinnings of global capitalism, of financial systems, of transnational property rights, of the ubiquity of corporations, which led eventually to a lack of governance and a complete ceding of space of regulation to technology companies. So we all live in sort of a lex technology companies now, whether we are governed by Google or Meta or X or Apple and Google, etc. All of that is now either completely derogated or the hypocrisies become too large for it to be sustained. I mean, you cannot seriously go and talk to anybody living in the Middle East today about international law. At the very minimum, you will be laughed at if you're not given bodily harm to, and I'm saying many people will agree. You cannot talk about that there is some justification, even with Iran, to a global sanctions-based order. My good friend talked about Iran living under sanctions. What is not expressed, because we have been unable to express that those are not multilateral international law sanctions, but unilateral sanctions by the United States, which are entirely without basis in international law. Yet we accept those sanctions vis-à-vis Russia, which are also unilateral, whether by the European Union or the US, which are multilateral, which have no basis in international law, without even blinking an eye, as something which is acceptable. So we are in a situation where international law as we know it is not fit for purpose anymore. Yet international law still survives. It survives because countries are still not doing their social relations with each other is not entirely made up of conflict. That there are alternative articulations of what international law should look like, and there are alternative pronouncements by the institutions of international law, whether it's the International Court of Justice on the West Bank or Gaza, or the coming climate opinion, whether it's the General Assembly, which as far back as the 1970s spoke about something which people completely forgot about for 50 years, which is the new international economic order and the complete primacy of sovereignty. We've had articulations of international law, whether it's President Xi in China speaking about Panchil, whether it's an emphasis on sovereignty, or whether it comes to Iran. And this is very interesting. So recently we've had, of course, the attack on Iran, and I want to use as a brief example of what I'm referring to. With regard to Iran, there has been, by some scholars, a articulation of a preemptive right to self-defense. One thought that after the Iraq war, that was done and dusted. But like Voldemort, it raises its head again. Like emergency powers, the preemptive right to self-defense, the same arguments used, the last window of opportunity. And serious scholars, people who claim to be serious scholars of international law, have pronounced that this is something which can fit into the window of what is international law, the interpretation of international law. And then there are those who argue against it, that no, this would as if there's any international law left to survive, that this would lead to a complete withering. All of this is being done without any reference, for instance, to the non-aligned movement's resolutions on the very restrictive use of what can be preemptive self-defense and the narrow articulation of Article 51 of the United Nations Charter, where is self-defense. So even when we are looking at studying this, and Iran has been a member of the non-aligned movement, which is, of course, is the intellectual history of Brics, there's not even a reference to it. And it speaks to the insularity of what international law has become, what comparative constitutional law is doing. There's not even a reference to TWAIL, or very little reference, of course, by most scholars. Or how does Iran view what international law is? Or how does China view it? Those views exist, and they are dismissed often as rhetoric, not opposed to as opposed to action. But what is international law but the rhetoric which can be spoken of? So that's an example, straightforward, on what is something that exists today. And of course, China and many other countries have expressed explicitly the fact, and it was spoken that China has not stood with Iran, that this was an action that was illegal in international law. So there is already an alternative that exists. What it lacks is a coherence and a study by scholars, because there has been, in academia at least, an insularity on what voices are coming out or what was considered the global south, which in itself is a misnomer now when we speak about it. The other example I will give is something that Ugo and I have written about recently, which is sovereign debt. So we've had a subject that is not studied enough, an entire legal institutional structure around the Paris Club built around how to deal with sovereign debt, which is you owe a lot of money, it could be to private companies. When you can't repay it, there is a monopolistic treatment by the Paris Club. Then the IMF steps in. I'm, of course, simplifying for the sake of brevity. Then the IMF steps in. There's a structural adjustment program. But now the debt is no longer held by people who have a monopoly in the Paris Club. So now you've got China being almost a majority holder of debt by what was considered the global south. So if it's Sri Lanka having a debt crisis, it doesn't need to be bound by the conditionalities of the Paris Club. Ethiopia, we talked about how that may change, but it can negotiate and set terms with India, China, and the constituents of the Paris Club on different clubs, so that monopoly is broken. In that monopoly being broken, there is now a different set of rules that govern sovereign debt and restructuring of sovereign debt. And sovereign debt is something which has affected and impacted more lives than any other form of international law, but is very little studied in the last 20 to 30 years. It's led to complete austerity programs, cutting back on agriculture, on medical funds, on everything. So how sovereign debt is treated, and what does the fact that there is a shift in financing of projects away from the traditional lenders, away from IMF. And one of the key changes, by the way, in the new development bank of Brics, to be specific, is that the voting share is not based on the amount you fund. So there is an explicit rejection of IMF voting in the new development bank, which is a Brics institution. So this is another example of something which is an alternative articulation that already exists. The key goal of Brics has been, and that's what's being expanded in Brazil, is changing global governance. Now we can debate ad nauseam whether the United Nations and IMF, etc., are fit for purpose, but the very fact is that they certainly don't reflect global power if it is represented through finance as it exists today. Today you have, we talk about capital, and we talk about global capital, and we still think in our minds that global capital is centered in London, perhaps a little bit in Frankfurt, and mainly in New York. But the primary, if you include in global capital what is held in debt of just the US and UK, the primary basis of global capital isn't New York, is Beijing. But the institutions don't reflect that. Because it's basically an over-leveraged corporation in the US, which if the lenders pull the plug on, as they've threatened to do, will not be able to finance its own budget, let alone its global power, which of course leads to a lot of chaos if that does happen, including a very large military. But these are actual, real global relations currently, what Professor Syed was talking about. That if global relations is formed by capital, which was a rules-based system that the US made, then the power in those systems has shifted. Just the people who hold that power haven't realized it, or belatedly perhaps they've realized it and are taking defensive action, perhaps too late. So when we talk about 41% of the global economy being now Brics nations, that 41% reflects global power, which needs a coherence on what their rules-based system is. It needs a coherence on what transnational property rights mean. One last illustration I'll make before I end this is corporations. Of course, corporations is very much a product of, a system of organizing capital which led, at least in the Indian context, but in many other countries, to colonialism. The East India Company, the Dutch company, were all forms of organizing capital which were used with royal charters to enforce and to create colonial structures around the world. The global corporation, till today, is formed within municipal law. It has no international treaties on how it can be treated outside of its borders. We recognize it, we deal with it as juridical personalities, but what is its liability, what are its property rights, where should it be regulated, are extreme questions that are being faced today. Just 2 days ago, President Trump called off talks with Canada because Canada threatened or said that it would enforce a digital services tax, just like the European Union is doing. Now, what the European Union, and perhaps to some extent India, forgot is that the technology companies were US companies, not just companies. China never forgot that. They always knew that they were US companies. And US companies will always have the twin which goes along with what US companies can do, which is the diplomatic protection of the US, which used to be called the Hull Doctrine or gunboat diplomacy. Trump has just modernized it in today's world. So we're dealing with technology, not these corporations not being global, but US. 4 big tech czars standing behind Trump when he's inaugurated. The power of diplomatic protection being used against sovereign decisions. And in the alternative, in how these technology companies are treated, there is what Professor Mattei talked about, an idea that the political trumps the private, at least in Russia, in India, in China. In India, it's coming back, which is being critiqued, but it also reflects a world which is more nationalistic in its economic relations, but within India it's being critiqued. But sometimes people say we're going back to the 70s. So in all of this, there are these things that are happening. The question is, who's studying them? And when I look out there, very few in Western institutions are studying them. Because there is still this idea that what happens in the West is what's really important. And in this, I read recently, you were talking about John Stuart Mill. And John Stuart Mill, I'm not critiquing him, but the idea of the other is he wrote in a review of Greek history that the Battle of Marathon, which if those of you don't go back that far, the Battle of Marathon is between the Persians and the Greeks. And the Greeks were highly Persianized at that point. There was no Hellenic culture. They were highly Persianized. They were vassal states, but there was a battle. But he wrote that the Battle of Marathon, which saved Western democracy and civilization, so the rhetoric never changes, is more important to England than the Battle of Hastings. So the other still exists, which is outside of law, which has nothing to contribute. And if we keep situating international law and law as being descendant from the Greeks rather than the Persians, and the global south, and I put that in quotations now because obviously, power has shifted, is academia and the articulation of law going to shift sufficiently is the question. Because if it doesn't shift, and I don't mean shift entirely, but if there isn't a comparatist approach which gives that articulation respect, then the third alternative is chaos. And with chaos always comes violence. So we are at that point, and it must be studied, and it must be given importance by academia. Thank you very much for your attention.
Thank you. Thank you.
Three speaks, and we would like to invite Professor Leopold to with the above speaks. Professor Leopold, the floor is yours.
I do not want to structure them by reference to the speakers because I believe that the gist of my argument and of my also critique of what I've heard will be very clear. First of all, I think we have to overcome a stage of debate whereby we are fetishizing notions and categories, like the market. And if we speak about analytical notions and call them, for example, or mention, for example, capital, then it is too abstract to say it's a system of relations, because then any rule-based system is capital. And this is not sufficient to specify, to describe, to analyze, and to understand. So I believe that we should be more specific and we should be attentive with respect to differences. And perhaps I cannot make myself clear when or I'm sure I cannot make myself clear when I refer to a multitude of arrangements, institutional arrangements in Brics countries, because simply I don't know them very well. My reference to the Constitution of South Africa is a reference to a constitution which I could read and where I saw a multitude of sources of law, of legal traditions, of their importance, of their hierarchies, but I don't know them. And I cannot judge them, I cannot analyze them. But I believe this multitude is the rich material of what we find in Brics. That means, therefore, when I speak about the differences and about the multitude, refer to something which is known very well to us. The cooperation is not the cooperation. There's a huge difference between the German tradition of cooperation and the Anglo-American tradition of cooperation. So we have to understand, first of all, the difference, second, where they come from, and third, if we realize that in current global markets, one or the other model is prevailing, then we have to understand why. But to speak generically about the cooperation or about the system of corporations is, from my point of view, not sufficient. So I insist that the interesting part of Brics is the multitude, it's the differences, and it's the unknown. It is not the stuff which we understand.
That's just the
Should I continue or not? Should I continue?
Please continue.
And not the stuff which we know from our own traditions. Now, there was a very interesting reference to the non-aligned movement, and I would like to take this up. If you study the protocols and materials of the Bandung conference, then you see that the difference was important. There was an underlying idea of positive creation, of creating institutions, of ordering in a different way than the way of the colonializers. It is not sufficient to simply reject and to define a project in negation of a hegemonic project. It is important to define it precisely in its new elements. So this is, from my point of view, the interesting part of an attempt to establish the Brics Academy. And this is how I understood also Roberto and his contribution to the conference which you referred in the morning. Thank you.
Interaction with the speaks?
Oh, thank you very much. Thank you for this possibility. I want to join many of the words spoken today. And Brics, of course, is an important and useful structure, a great structure. But let me remain a bit skeptical. It is more of an applied tool for solving practical problems. It's either Norbert. I'm sorry. And secondly, it seems to me that we will never get away from the property rights. If you don't protect property rights, investors won't come to your country. If you cannot be an autonomous economy, you cannot do without the legal protection of the individual interests and of the property right. Sorry for my vision, but I have some kind of inside look into the Brics, and I hope it will be a little bit important. Thank you very much. Thank you very much. Thank you.
Let's now give the floor to Professor Teramo.
So, I think I only really picked up the aspects. First comment clearly enough, and I guess it was somewhat directed in my remarks, so I can respond to those. And maybe I'll say something on the line, but perhaps I'll leave that to Professor Singh, since I've been as well. I'm not sure I understood the point. Something about call capital. First, there was something about two abstract concepts and verification. Maybe he didn't say verification, maybe he did. So we have to situate this debate. There is a position called critical legal studies in the United States, which had a deathly fear of saying anything substantive. So it was constantly saying everything was too abstract, it's indeterminate, what about this, what about this? Now, the genealogy of that deathly fear in both legal traditions of theological scholasticism and mistaken French ideas of so-called structuralism, but I won't do that here. The point is, I don't have a deathly fear of reification because I know concepts and tools for thought that you specify in a concrete way and develop over time in accordance with our purposes and context, and not to be taken as essences which are to be either deconstructed or defined. Now, on the specific concept of capital, the idea that I said it was a system of relations and therefore it's too abstract, everything could be a system of relations, well, of course that's true. That would be an infantile absurdity, but of course I didn't say capital was a system of relations. I said it was a system of market-dependent relations, which I didn't have time to specify in their full concrete delineation, but they involve vertical relations of class with respect to those who own the means of production and those who own nothing but their own labor, and as horizontal relations of commodity form or market-mediated, price-mediated exchange. And I could elaborate more. Capital is a system of social relations of market dependence, which generates its own form of vertical relation and impels everyone in the system to grow or die, innovate or die, reinvest or die, and has resulted in a fundamentally new phenomenon in modernity, which the mainstream liberal misunderstands to be something called the Anthropocene, as if that's what it is. That's a scientifically illiterate concept, the Anthropocene. It's a kind of absurdity, and then they chase various things. Is it Hiroshima? Is it the Industrial Revolution? They have no idea what they're doing because liberal thought has no analysis of anything. Liberalism is to invert cause and effect. Everything that is an effect is taken as for real and the cause. And the response to liberalism isn't deconstruction and postmodernism and critical legal studies. The response is to try to name and articulate what is rendered invisible by liberal individualism, and that is the social relations of modern society, which are capital and then its outgrowth in geopolitics as imperialism, etc., without reifying or fetishizing the other word he used. Okay, and so if there's something wrong with the conceptualization I offer, fine, I'm happy to hear it. But there's a conceptualization offered. Similarly with property, I was extremely precise with what I said property was, and I'm happy to defend it. Certainly against the obscurantism of critical legal studies, which thinks property is some sort of holy magic water which has to be averted, and also it can be deconstructed into 18 million things, but never once can we say what it is. This mode of thinking, which is supposedly critical, is in fact just liberalism in its extreme. It's just a continuation that we can never name anything, and if you can't name anything, you can't see it, and if you can't see it, you can't critique it, and if you can't critique it, you can't transform it.
Thank you. Yes, as I know, on this floor there is a very famous philosopher from China, Professor and President Tong Shijun. Welcome.
And I would like to just make some remarks, maybe very, very simple, maybe not so innovative. But anyway, I think it's important. The first point I want to make is that the current major narrative of China's development or China's reality, I would say, is national rejuvenation through modernization and socialist revolution. So there are three themes. These can be understood as three stages of the historical development of the country in modern times. These three themes or these elements can also be regarded as three dimensions of the social reality of contemporary China. And I would say these three perspectives can be also found in the self-understanding or intellectual reflection on or expectation on the future of China. 3. I mean, that's probably also something we are familiar with the Hegelian philosophy. 3, the number 3 is particularly important. 3 stages, 3 dimensions, and I would say 3 perspectives. These 3 perspectives are not just put side by side. At this moment, each of these 3 themes should be understood or interpreted with reference to other 2 perspectives. I can say more, but I want to stop here. And then the second point I want to make is that because this is a conference on political economy of law, somehow about philosophy of law or legal theory. And I think in current China, the typically modern tension between the principle of popular sovereignty and the principle of the rule of law is being mediated by the third principle, which is the leadership of the ruling party as the vanguard or pioneer force. This is explicitly stated in official documents in China. 3 principles, 3 ultimate principles: people's sovereignty, 人民当家作主, and 依法治国, the rule of law, and 党的领导, the leadership of the ruling party. I think this can be understood as a kind of a way to address a typically modern challenge. In the West, you also have the tension between the principle of popular sovereignty and the principle of the rule of law. As actually we are witnessing what is happening in the United States every day these days, right? These principles, these 2 principles are equally important, but they can be in great tension. Now, how to mediate the tension between these 2 principles? I think that's the role played by the leadership of the ruling party in China, because in China we don't have a history of civil society. We don't have a church tradition, all these things which are important in mediating the tension between these 2 principles in the West. We don't have these things. So that's why the ruling party's leadership is important. As an, I can give quite important evidences. Just in the last decades, in the period of the reform and opening up, you can clearly see the role played by the ruling party in introducing one after another important ideas, and these ideas are not simply ideas. They were put into constitution and they were turned into practical policies and become part of reality. Like in 1992, the idea of socialist market economy was formally officially introduced. In 1997, the idea of the concept of a socialist rule of law state, 社会主义法治国家, was officially introduced. And in 2004, and the socialist harmonious society, not socialist civil society, socialist harmonious society. The important thing is that the idea of society was finally introduced into China, which would otherwise be regarded as a statist country rather than a societalist country. And then in actually also the same year, 2004, the concept of human rights was introduced in the Constitution. And in 2012, the idea of human rights was finally introduced in the criminal procedure law. So these important steps were taken by the ruling party. Okay. Now, the third point I want to make briefly is how the Chinese government or the China as a country is understanding the international order in our times. China has been frequently regarded as a country which not only has the power but also has the intention to change the international law. That's actually quite complicated. Recently, let's put it that way. At ECNA, I'm from East China Normal University, and I'm also the chancellor of NYU Shanghai, because NYU Shanghai is a joint venture university between NYU of the United States and ECNU, East China Normal University of Shanghai. So many of my academic activities were conducted at ECNU. We invited the British historian Perry Anderson to give a lecture at ECNU, which was actually on the basis of a paper published in the New Left Review about international law. So he made a quite sharply critical critique of the idea of international law in the West. Then I was one of the three commentators on his speech. My idea was that it's very important to have a sense of difference of context of speakers and listeners. It's very good for Westerners, for a Western intellectuals, for a Western scholar to make self-critique of the modern Western tradition, or modern Western legal culture, all these things. It's quite another thing for me as a Chinese scholar to to see the situation, to see the issue. The same sentence, the same proposition, if expressed by a Westerner and by a Chinese scholar, they can mean quite different things. All right. So, from my perspective, I think it's very important to prevent the thinking that now it's our turn to use international law as merely an excuse to plunder, to do plundering. Now it's our turn. No, I mean, the Western legal culture is complicated. And I managed to find the materials in the parliament debates of UK during the Second Opium War. There was a heated debate, and some British politicians defended Chinese interests sharply against the British military intentions. And I think this tradition should be respected, and we should learn from that kind of tradition. And actually, towards the end of the 19th century, some Chinese scholars and hierarchy officials already saw that, yes, Westerners often took advantages of international law to do bad things toward China. But China would be, actually that China was more badly treated because China was not a part of the international treaties, not recognized as a member of the international order, because this international order international treaties properly understood can become a protection for the Chinese interests at a certain level. So that's why the current Chinese government claimed, I think Chinese government position should be trusted. That is, we benefit from globalization, we benefit from the global order after the Second World War, and we benefit from the UN organizations. So we will continue to play the role of defending, safeguarding the normal international order. So that's one point I want to make.
Thank you. Okay. Yeah. Okay. Yeah, let's turn the floor to Professor Rafael Zanatta. Okay.
Thank you very much. It's a true pleasure to be here. My name is Rafael Zanatta. I'm from the class of 2015, so 10 years ago, and now I'm currently a faculty member, and it's great to be here in this position, also honoring Professor Mangabeira Unger, who in my career has had a really strong influence. I studied Mangabeira's Unger work 15 years ago, and his work of systems of right, and my master's degree in Brazil was about him, so it's very symbolic to be here in the same day as he's being honored. I read the report on Brazil, and I would like to offer some additional comments based on my perspective, also as a director of a digital rights organization based in Brazil. We were last year working very closely to the Brazilian Ministry of Foreign Affairs in the G20 process. We were part of the T20, which is the think tanks coalition around the G20, working on inclusive digital transformation. And we've been following this transition between G20 and Brics this year. Brazil is holding the presidency of Brics, as you all know, and we've been observing very closely what is going on regarding the agenda setting and institutional transformations. One thing that is very important to note as well is that last month, in the end of May, beginning of June, we had the first seminar in the Brazilian Congress, which was the Brics Parliamentary Congress, which brought together congressmen from China, Russia, and Brics members inside the legislative power in Brasilia. And this is a very symbolic move, because this represents that Brics is not only a powerful agenda from the executive power, but also it's a Republican issue. So once you have the Congress of different countries holding seminars and exchanging ideas on how to do law, how to produce law, that's very symbolic, and that should be observed as well as one important movement that is going on in the Brazilian presidency of Brics. I would also like to point that, going back to Mattei's taxonomy on traditional law, political law, and professional law, we should pay close attention in Brazil to the cosmologies of indigenous groups and the way they perceive law. This is very profound. It has a lot of richness on the way indigenous intellectuals are working around social theory and the way we organize society. So, for instance, we have one really important intellectual, indigenous intellectual, called Ayrton Krenak. He's a highly influential indigenous leader from the Krenak ethnic, and he's been a campaigner against big developmental projects in Minas Gerais and big companies like Vale and others who are exploiting natural resources. And for the Krenak ethnicity, when you are exploiting minerals from a mountain, you are somehow killing their grandfathers. So the mountain is like someone else, is like a person. The mountain is like a grandfather. The mountain has legal rights. This is a very profound and radical different way of thinking as we have in Western societies or traditional Western thinking in Brazil. So if we delve into Krenac's thinking, or if we go and read the work of anthropologists like Eduardo Viveiro de Castro, who's an important anthropologist in Brazil, they will show the richness of the thinking of those communities and the way that there might be some important clashes between, this idea of a new developmental state and big projects and economic projects on, hydroelectric farms or exploiting minerals and so on, and profound clashes between basic ideas around what is a resource. Because for them, it's not, a land is not simply a land. The resource is not simply something outside the human nature. It is part of their own believing on the complexity of the living beings. So we have a lot to learn from those indigenous communities as well in legal thinking. It would be very interesting to observe also how those ideas between those cosmologies in traditional law somehow might inter-exchange between Brazil and other countries. Well, I would also like to point to the fact that more specifically on Brics and this agenda with Lula, of course, this is a key priority for the Ministry of Foreign Affairs since the first Lula government, this South-to-South cooperation. And of course, with the third term of Lula and the appointment of Fernando Haddad, who is the Ministry of Finance, to work with Lula, there has been a strong effort in reforming the international structure of the financial system. It's important to recognize as well that Brazilian former President Dilma Rousseff, who is in the presidency of the Development Bank, is also a symbolic move and political effort from Lula government to reinforce this kind of partnership. But I would like to point to the fact that before Brics, we also had a very strong effort from the Brazilian government in establishing South-to-South cooperation within Portuguese-speaking countries. So actually, the first effort that we had more than 14 years ago was to establish this alliance of Portuguese-speaking countries on the South-South to develop research, development, university cooperations, and so on, and forming this Global South Alliance of Portuguese-speaking countries. This is very important for the future of the knowledge economy and AI development, because one of the biggest concerns that we have in the digital economy community, developing like natural languages models and AI systems, is the centrality of language and the possibilities of enhancing cooperation between Portuguese-speaking countries. We do have a lot of Portuguese-speaking countries, and Brazil is working hard to establish this kind of partnerships. Also, I would like to point to the fact of it would be very interesting to observe and to study as well the role of Brics and the future development of what we might call digital rights, or this idea of fundamental rights being shaped by processes of datafication and platformization, which are two huge social phenomena occurring in this century. We might observe that just after Edward Snowden's case in 2013, actually Brazil, China, and Russia made some efforts on data localization policies, which took different effects. So China and Russia went one way, Brazil went on another way on data localization, actually got it back and followed US policies on this subject matter. Brazil also followed a very strong policy on platform liability, making sure that big techs would not be prosecuted or would not have any legal liabilities for third-party content, which was just rejected yesterday. The Supreme Court of Brazil just declared the inconstitutionality of this rule of 2014 on platform liability. So things are changing fast, and we might have a somehow Brics effect on digital rights as well. Also, it's important to notice that when the Brazilian Supreme Court clashed with Elon Musk last year and suspended X from Brazil from operating for some months, that also generated a kind of a precedent for rule of law and the role of protecting the sovereignty of the legal system. which has sparked some interesting conversations about how Brazil might exchange knowledge on protecting the integrity of the legal system in comparison with other BRICS countries. So, of course, Lula has been very vocal about that, and we notice in Brazilian speech that the harms of big techs on Brazilian society is one key element for also fostering better development and cooperation within the BRICS community. And also, they have been very vocal about the role of AI regulation within BRICS. In the last 3 speeches that I heard from the Ministry of Foreign Affairs regarding the key priorities for BRICS and Brazil, of course, there is to fight hunger and poverty, to reform international institutions, to develop cooperation on economic development, of course, but there's also the role of AI regulation. And AI regulation is not only related to the role and the functions of law in determining rights and obligations and duties, but also the major role of digital public infrastructures might have in the future. Brazil has been advancing a lot of projects like Pix, which is the instant payment method, or the system of electronic petitions, or interoperable systems which might be framed as digital public infrastructures, as the Indian government has somehow declared 2 years ago in the G20. But this is an interesting combination of industrial policies and set of projects which are aiming to autonomy of one country and better deployment of public services together with technology. And it's a way to somehow avoid the dominance of big tech or AI big companies from the US and other countries. So we also believe that digital public infrastructures should be one interesting topic for comparison, for analysis within the BRICS, because there has been a lot of influence between India and Brazil specifically on this topic. The Brazilian government has been traveling to India a lot to learn from them how they did the Indian stack, how they did the digital ID system, how are they deploying those digital public infrastructures as one strategy to advance in this AI model. So these are my contributions regarding the report, which is beautifully written, and some additional comments for you. Thank you.
Yeah, Avi
I just wanted to respond to Professor Specht on the non-aligned movement and, sort of this. Oh yeah, sorry, is that better? Yeah? Nobody's ever said I'm not loud enough. But this idea that there is sort of an idealization or perhaps nostalgia of what the non-aligned movement was. Of course, Tito and Nasser and Nehru are not to be compared with the articulation of what's happening. But their ideas still persist. And I just wanted to take a minute because the 1954 Sino-Indian Declaration, which is the Panchsheel, the 5 Principles Declaration, which has as its bedrock the equality of sovereignty as opposed to real political power equations between countries, which is sort of the new Trump model, but has been the model for Kissinger, has been sort of a bedrock of many relations, still persist in rhetoric and something which is being re-articulated both in the Shanghai conference as well as BRICS. And that is a change. And certainly in times of, conflict, hot conflict, and neither China nor India nor our neighbors are outlawing war. We have a small little skirmishes all the time. But the idea of international relations based on non-aggression and equality of countries is in itself a radical departure from the world we're in today. And that rhetoric is important because both the Chinese leadership and the Indian leadership and others are adopting it. Because if that persists and we are able to articulate that differently, that's not less idealized and less radical than what was there in Bandung and Belgrade. And that's certainly in the Venezuela Declaration of Non-Aligned Movement. And it shows also that every single BRICS country have refused to implement the US sanctions on Russia.
Okay. Thank you. And Professor Leopold, do you have any back to Professor Avi's? Okay. Oh. because I got a message that Professor Leopold will leave in 10 minutes. So if you have any back to all these speakers, or if you have any word to our audience, Professor Leopold?
No, I would not.
Okay. Thank you very much. And let's open the floor to all our audience. Okay, yeah. Yeah. No, you just take.
Should we move? Yeah.
Yeah, absolutely. You can all hear me. My name is Nidhi Srinivas. I'm in the New School in New York City. This is a really fascinating event. So I have actually two comments, or if you wish, provocations. The first is, there is a presumption here, if you wish, a tension, that we can move from one model of capitalism to another. I remind you here of Talha's comments earlier this afternoon. If we see capitalism as a system of intensified, expanding commodification, it does beg the question if the Brics alliance offers a different model of such intensification and expansion, or it actually signifies the end of capitalism. And I think that it's rather clear in the discussion we've had that it isn't really discussing or presaging an end of capitalism, which then makes me ask, in what way could it either intensify capitalism or expand capitalism, or even, dare I say it, reform capitalism in some sense? The second is, the second aspect has been gestured to some point, but let me offer you this through the work of an extraordinary thinker who I think isn't sufficiently acknowledged when we discuss the Brics. This is the Brazilian thinker Rui Mauro Marini, who spent much of his life in exile in Mexico. Mauro Marini talked about two forms of prefixes, if you wish. One was sub-imperialism and the other was super-exploitation. Sub-imperialism is when you recognize that a trade agreement leverages economic power, territory, it moves into geopolitics. If you wish, Brazil's relationship to Paraguay is a very classic example of sub-imperialism. As Marini reminded us, the Itaipu River is basically owned by Brazil, though it's actually a river that separates Brazil from Paraguay. Now, Brazil's history is the history of a sub-imperial power. It was a sub-imperial power for the United States during the coup. That did not mean it was a subordinate power alone. It sought to leverage its own power. And after the coup, its history, including under Lula and Bolsonaro, has been a history of leveraging, if you wish, the influence of the United States. So the question I would then ask is twofold. Does the Brics imply all of its members are equal, or does the Brics imply a sub-imperial arrangement? For instance, Ethiopia becomes a sub-empire, possibly of China. India becomes, dare I say it, a sub-empire of China if it will allow it. May I point out, India remains deeply trade dependent on China. And if that's the case, is that all right? Because note that if we're looking at it in this latter situation, we're saying essentially we're moving from one kind of hegemony to another. And then the question really becomes how to educate a sub-empire into becoming an empire. In short, how to encourage China to take on the reins of becoming a global hegemon in the future. Those are the two provocations I wanted to add. I'm sure the others would like to add other comments to it. Thank you.
Okay, thank you. Anyone? Anyone? Okay.
Thank you very much. So, yes. Hi everyone. I'm Golnoosh Hakimdavar. I was in Torino, I want to say 15 years ago, 2010. Graduated from Munito with my PhD, and then went on to teach at Northeastern University in Boston, and ended up in the US government. Is this being recorded? So, so a couple of things here. We're talking about access and control. And one of the areas that we haven't really talked about were resources and environment. When we talk about resources, I mean, we're living in a time that we are engaging in deep sea mining. We're mining for nickel and invading the privacy of our oceans. And we're not really addressing this as an issue. This is very emotional to me because when we think about kind of our environment, it is, and the way that we're engaging it, it's, we're closing our eyes. The UN even held private sessions on how to engage private companies in deep sea mining. And governments were not really involved in that. The BRICS countries are actually part of the original BRICS countries are somehow in the conversations on research in deep sea mining, but actual drilling is taking place right now. And there's a private company in Canada that is like their stock is going up since the new US administration. This is a major issue, and we're not really addressing it. Another area that we're not really talking about is access to water. When the attacks happened on Iran, I'm also Iranian. When the attacks happened on Iran, 10 days after the original attacks, Iran attacked Qatar. And the main part of the conversation was, what will happen to Qatari water? They have enough water for 3 days to survive. And this is not just an issue with Qatar. This is an issue with most Gulf states. What about water? Water is a major area that causes conflict between countries. We are going towards drought. I mean, it is so warm here, but imagine like the deserts are increasingly going towards drought. And these are two areas that we need to be kind of really thinking about as BRICS countries, as BRICS is also kind of forming, even if not institutionalizing, but still forming to, in a way that they have more access and control. So expanding that, so that's one area that I think we really need to bring into the conversation, which is resources, access to resources and how resources are being distributed. Another area that I think we mentioned a little bit this morning was data. So who has the right to have everybody's data? All of our information. The previous question was about, on Brazil, I'm sorry I didn't catch your name, but you were talking about kind of digital law, right? Looking at law and how it impacts the digital world. Well, the thing is, this is all happening so fast that law is actually falling behind. So all of our data is currently accessible, but certain countries have privacy, they have protection, and others don't. I have, since January, and a lot of changes in the US government, I have kind of taken on a new role where I've been looking at health data. Because the US does not allow access to a lot of health data, especially on women's health, we can go actually outside of US and very easily and at a very cheap price get as much data as we want. There's a problem with this because this data is associated with, every bit of it is associated with a human being. And based on that information, we're making decisions. So that's another aspect that we need to kind of think about access and control. Who has access and how do we control this information? AI is another dangerous area when we think about data. What is being fed into AI, what is being fed into regenerative artificial intelligence is what is giving us the results. So if most of the information that is being fed into it is coming from Anglo-Saxon Americans, it's going to give results that is going to be for Anglo-Saxon Americans. It's not going to be thinking about what is happening in South Africa or it's not going to be giving us results that is thinking about what is the Iranian population, for example, how are they affected by this, by the information that is given. So that's another kind of area that we need to be really thinking about. And now I want to shift a little bit to economic disparity, completely separate, because we talked about, we had our Iranian colleague who talked about the SWIFT system. And this is really a failure of international law. And Avi mentioned the sanctions, the unilateral sanctions that U.S. has had on Iran as one of the countries that has been on the severest sanctions for the past 20 years. The SWIFT structure is what gives you access to trade, right? To be able to sell products overseas. And essentially by limiting the access of Iran to SWIFT, they have cut off ties for the entire country to any kind of economic development for the average citizen, not for the ruling elite, which keep on getting richer and richer. If you have seen the recent attacks on Iran, it's amazing. The most beautiful areas of Tehran are being attacked, and who is being targeted? The top of the top, the cream of the crop of the regime, because they live in the most beautiful homes in the top penthouses in the best areas of the city. And that's because money is being funneled into certain parts of the country. And this is not unique to Iran, I'm just using it as an example. But international law has been failing in pushing back against these types of unilateral sanctions that have a multilateral effect on countries. I mean, SWIFT, until very recently, SWIFT was the only way you could trade, that you could actually send a shipment and then pay for it, or receive a shipment and pay for it. So this is where Brics can really be coming in and saying, okay, how do we create parity and go away from this disparity in the economic setting of countries? Someone just right now, I'm sorry, I keep missing who said what, but someone just mentioned that, are we coming at Brics from the idea of equality? No, absolutely not, because the countries are not equal. We have some with much more political power, we have some with much more economic power, and those like Ethiopia or like Iran that are struggling on different fronts. And we need to think about how do we push back against the access and control that has been held by the Western world. And Brics is really a way to push back against that and create a little bit of that parity and that especially economic parity. Last point I will say is on the domestic legal structures of countries. And I think this goes back to what you were talking about on kind of law being the social construct, the social agreement, right, in societies. Some countries don't have that luxury. I mean, going back to the Iran example, this is a country where at least 50% of the population have no say in the law, right? When we think about how the law is written, the judiciary, the economic council, the guardian council, none of it have any part. Women have zero say in any part of this. So women are subjects of law, and the law is imposed on them in this country. So they're not part of that agreement. They're not part of that contract. So that's another aspect that we need to think about is where are societies are people being treated equally under the law, and are they actually being engaged, or is it just kind of imposed on them and that's it? I think that's all the points I had. Okay, one more point and I'm done, I promise. I have to say this. We are actually experiencing right now a time where the traditional economic rationality is being used as the reason for actions. As an example, in Gaza, right? There is a sitting president who says, I am going to take this land from these people because it makes a wonderful resort. And that has been said. I mean, this is absurd, and there needs to be pushback against that. I mean, this is where there was a comment about property rights. Yes, property rights are important. This is these people's land, belonging, home, everything that they have, and a decision is being made on, no, I'm just going to push you out, move you to another country, and use the land to make a resort. And it's absurd. And this is a responsibility that Brics has, and I think it needs to be coming into the conversation so that we are creating a little bit of that parity, hopefully, in long term. All right, I'm done. Thank you.
Yeah. Thank you. Yes. Okay, Professor Ignazio.
Hello. Good afternoon, and thanks to Ugo for making this possible, and to all the new friends. I'm Ignazio Castellucci, Italian, born in Argentina. So it was an almost Brics country, having taught in 2 other BRIC countries. I have some remarks. It's not really anything particularly intelligent, perhaps, but what I notice is that we are discussing BRIC since almost 20 years and BRICS since more or less 2009, since Yekaterinburg, when South Africa joined. And what is remarkable is that the BRICS discourse, in my opinion, is very much centered on geopolitics, which is quite obvious. And we see a lot of discussion about the dynamics of the growing team of BRICS plus countries vis-a-vis the northern globalization and the new fragmentation of the world, developing a global south with its own political institutions, dynamics, sort of adversarially, if not with enmity with the global north. So clearly there is something interesting there. But as legal scholars, me as a legal scholar, I don't see an equal amount of geo-legal issues developing out of this. The law remained back a little bit, as it has just been said by the Iranian colleague. Not because of technology, of course, also because of the fast pace of technology. But even 15 years ago, when the law was still working with the old technologies of the 20th century, it was already remarkable how the legal discourse was relatively absent from the general BRICS discourse. So in geo-legal terms, in geopolitical terms, everything we heard is quite appropriate. Is it a global south against the global north? Is it a number of new empires emerging from the south? Do we have one, possibly 2 new global empires from the south, developing a network of sub-empires all over the place? Everything's okay. We'll see. But in legal terms, if you want to have an empire, you need a legal system. You need a legal frame, a legal ideology, which is one of the pillars of any empire. You need the military, the economy, a culture, possibly a currency, and a legal system of sorts. So everything is growing, perhaps slowly, but the only legal element I saw, which can qualify as a technical feature of BRICS countries, I think it has mentioned earlier in the afternoon or this morning, is what I read in the Fortaleza statement of 2014. Namely, the idea that BRICS countries treasure, value, leverage the idea of public and private cooperation for the development of the economy. So this is something. This is probably the only common legal elements among the 5 original BRICS countries. So little has been developed out of it. So BRICS related scholars discuss a lot about the usual political things, but we do not do enough data collection on the legal dimension, which is okay if you're not a lawyer, but it's unusually weird if you are a legal scholar. Because, of course, it's nice to look geopolitical. You know, these times you look intelligent if you discuss about empires, blah, blah. But we're lawyers, fortunately or unfortunately. So we need data on the legal dimension. Each scholar from those countries especially should contribute data for us to analyze, because the places where the most where legal information is mostly available in the global north, through databases, through libraries, is mostly a place of Western or Western-related law. So we lack the data we lack to assess how is the geo-legal dimension of Brics growing. Is it growing at the same pace or a different pace, or not growing at all, or going in different ways? So this would be very interesting, and personally I'd much like to hear from BRIC countries, scholars, how is the law developing with a view to somehow enacting or being consistent with the idea of Brics. Thank you.
Thank you. Next, let's invite Sasha.
Hi everyone. First, thanks Ugo and Pep for organizing. It's a wonderful event and it's good to be back. I am 1 year after Rafa, 2016, so still not 10 years, but hopefully next year when we see each other here it will be 10 years for me as well. Also, a great report. I really liked what I heard and what I saw, and I'm going to read it in detail. Just a couple of comments. So I work in China, in NYU Shanghai. I came with Professor Tong today. I teach economics. The comment I wanted to make is I felt there is a strong current here of what is definitely an anti-authoritarian, possibly anti-statist standpoint of critique. And I think we understand this very well. In the West, we have observed the interaction between capital and the state in capturing politics, imposing environmental costs, imposing social costs on us. I think this is quite obvious for us today. But I feel a little bit uncomfortable when we apply this to Brics in a straightforward manner. What do I mean? I feel that what are these countries that make up Brics? These are states and economies, social systems that have developed under US hegemony in global capitalism during the 20th century. This is what they are. To think of them or expect of them to change overnight into something that they're not is, I feel, an idealist point of view. I think as good materialists, we need to understand the material conditions on the ground, the conditions of, this is what these countries are. They're nothing else but this. At the same time, and I feel this is what is kind of the task for us, and I feel in this kind of comparative legal and institutional endeavor that we have looking at these countries, something that we should focus on is to what extent in this diversity of their institutional legal systems there are counter logics, we could call them, phenomena, institutional arrangements that do not follow along this neoliberal, let's say, logic or trend. Do we see things there, both statist and non-statist? And I would say if we can see statist things that are somehow contradicting this general logic, we should consider them. We should see whether they can extend. If Brics, in my mind, you know, and I'm just a humble observer here, I'm not really a lawyer, so I don't feel I have the capacity to say anything. what Brics law could be about is understanding if some kind of international legal order that emerges as US hegemony falls apart could support and develop these logics that do exist in these countries in one way or another, right? You will not find in China what you will find in the US. You will not find in Iran what you will find in the UK or in India. Now, you will also still find many of the statist capitalist institutions, because these are statist capitalist projects that have developed within global capitalism in the 20th century. I think that's a given. So the question is really, is there anything else there? And I would say this diversity that we observe, and we can go into many examples here, I think all of us have them, is that there is something else there. There's many other things there institutionally. And the question is, can they survive? Will this international system that is appearing support them or inhibit them into a new stage of capitalist accumulation? That's it.
Thank you. And anyone else? Okay. Matteo.
Hello, everyone. I really would like to ask you if you know Tether. Somebody know Tether? Raise your hand. So, Tether is a technology app you can download and use, and it's different from blockchain, Bitcoin, so on, but has spread, especially on Brics, and allow the access to bank services to the people who was not allowed to have access to the bank services worldwide. So that's helped a lot, let's say.
In Africa.
Yeah, especially in Africa, of course, but more or less worldwide without banking services. So I don't know how to catalogize heterodox, orthodox, whatever, but Tether has been made by two guys from Turin, one dentist and one IT guys, and they were no under United States, Italy states, European states. They were under guidance of some political, let's say, party, but they just saw this opportunity to help people reach the bank services, and now they are making a lot of, let's say, difference into the. So I just want to bring you to your attention these things. Thank you.
Okay, thank you. Thank you for your sharing this updated information. And yes, the gentleman at the end. Take a seat.
So hello to everybody. My name is Aleksandar. I'm coming from Belgrade, University of Belgrade. I'm LLM in economic analysis of law. I'm coming from the country that was, let's say, pioneer in experiencing the crushing of the international law. So Yugoslavia was the first one who was, let's say, taking aggression from West without the Security Council of the UN. So in our experience, we know and we feel that international order or international law is not at live or is not in well-being that it should be. The thing that I think that is one of the ideas why Brics became what it is today is actually those kind of happenings where you're crushing the international order without any concerning about international law. Because during that time you didn't just have aggression on the Yugoslavia. You also have destruction and bombardment of Chinese embassy in Belgrade, also by accident, of course. But in my opinion and opinion of most, let's say, Serbian guys, we are not officially part of the Brics, but we have popular vote. Let's say one day we will be. What we think the Brics is, what the idea of Brics is, that idea that that kind of international law and international order could exist. That's why we fight for that. That's why we can oppose the West and this kind of hegemony that is right now, so we can live, let's say, in more, in better society. I know I'm sounding really young, I'm idealistic, I'm whatever, but what's the point of doing this conference, doing the politics, if we don't believe in those kind of stuff? So what I heard today are really good. You are experts. You are really good in the subject of this. What my question is that I do not get. Brics for right now, if I saw it correctly, is together and trustful between each other. So nations, the blocs trust each other because there is bigger enemy. There is enemy who is constantly crushing the international order, that do not care. We saw in a couple of days ago, 2 weeks ago in Iran-Israel, let's say, war, we saw that one side actually do not believe in international order. We already had that talk here today, that kind of preemptive defense. Whatever we think it's right, we can preemptive defense. So if we think that you can develop nuclear weapon in, let's say, 10 years, we can preemptive attack you because, yeah, we need to protect ourselves. It is funny to see that two nuclear powers attack one that has not nuclear power because they are scared of that country to get it. So what, if we believe in those kind of stuff, we need to see that hegemony, that constant breaking of international law is putting these countries together. And when we speak about this declaration, about this soft legal power right now, that we are, let's say, making together concession about how, let's say, we will do the AI, do the water and everything between ourselves. There is one thing that is connecting the Brics right now, and that is the fear from the other side that is singularly stronger in every way than any member of the Brics right now. But my question is there, for you, of course, and for everyone who is expert on that, is there a viable, let's say, theoretical foundation for legal harmonization that will respect the culture sovereignty, yeah, and civilization difference between those states? So in the long run, if, let's say, Brics manage to stay alive, win this kind of battle, what is the next step? So how should we make our international law order then? What will connect us then? Because now we have that soft power and declaration, but we all know that for law to endure and to exist, there need to be consequences when someone breaks that law. So what will happen when we do not have anymore that, let's say, outside threat? What will happen then if someone breaks the law? If, for example, let's say Serbia is in Brics and we are AI superpower in that moment, and we break the law and break the declaration about how we will develop AI. What exactly is the consequence for us? So someone sue us, to whom, how, and what law will be taken? Because if we take all of the civilization differences, that I think is the best thing about Brics, that we actually embedded our civilization differences in China case, that combination of Confucianism and Marxism that is good, that is great for their nation. In our, and of course, Russian case, there is Orthodox Christianity that is embedded in our culture. it is good that when we talk about geopolitics, where countries between themselves, they can manage to deal with the problems. But let's say the Chinese company and Serbian company are have differences. Where is the arbitration? Whose law will we take, and what will be the consequences if something like that happens? So speaking about that, my question is, how do we envision the role of that legal discourse that is rooted in Global South tradition? So in, let's hope, post-Western world order, and will this just be a tool to make some institution develop, or some kind of legalization and belief in that new international order? Thank you.
Okay. Yeah, we still have the lady. Yes, you. Yeah. Okay.
Good evening, everyone. I'm just going to continue what I was thinking from the last speaker's interventions. Just a small remark. My name is Sirat. I am ex-student from IUC from last year, and right now I'm working with the IUC Legal Clinic for Refugees and Migrants. Just the same thing that you mentioned, I was thinking about that in the whole discussion of the day, we somehow were focusing on Brics plus legal systems from a very political and economic lens, and where is the juridical questions and what is the commonalities that exist. That for sure is important. But when we are questioning about the international orders, aren't we talking about dismantling or recreating or reimagining a world where there is an order? Order exists when there is an outlook to it, and that exists somehow when the question that nobody is, I don't know, are we shy to question about the military harmonization and the legislations or legal questions regarding armament or disarmament within BRICS plus countries? Because yes, it's the difficult task. And exactly what happens if this BRICS plus exists and it's meant to grow? After that, we need something. We need a system or harmonization of the legal order of armament, disarmament, militarization, or demilitarization, whatever it is. So we need to think that at this moment, because that is like thinking that we want to bring something alive without thinking of what we should shield it with, and only thinking about what we should feed it with. And without thinking about the shield and the protection and how it would be protecting itself and from whom and how it needs to protect others around it. For me, it seems a little bit absurd and talking about something that might not be able to exist as such. Why this is important, not from a very question that might exist in future or very idealistic future, is because the countries right now, which we are talking in BRICS, which BRICS Plus, they are in this moment involved as perpetrators somewhere, as victims somewhere, in wars. And they are bearing the consequences of the current international order around armament and militarization. No matter what you say, no matter how much political and economic leverage you have, the end question at the D-Day comes is, who has the power to nuke who? And this is important, and not sitting here and even having and shying away from fathoming that these countries can have their own set of military legal systems is, I think, thinking that they might always stay baby and never become a warrior. Thank you. That's all.
Thank you. And as I remember, yes, young lady, you're welcome.
Good afternoon, everyone. My name is Parinaz. I'm from Iran. I have the LLB of Global Law and Transnational Legal Studies from University of Turin, and I work with the law of AI in the European Union. You talked about the Tether. That was an interesting point, but the funny thing is that Tether was created as a decentralized idea, but now if you look at countries like Iran, again, there's a loop that if you want to use Tether, you have to be connected to some other bodies, like outer government bodies. So like, I want to say that like Bitcoin and decentralized blockchains, they started as the idea to let go of that centralized economy, but failed, at least in countries of Iran. But I want to like address something about the Brics, maybe to address one question. Do we really have the digital infrastructure that we need today in order to present ourselves in the eyes of global? Because, I mean, I have a question, have you gone to the website of the Brics? It's non-existent. It doesn't work at all. And we live in attention-based industry. We need to use social media, website, AI, and everything that is existent in the digital world to present ourselves, to advertise. Otherwise, we can like do this like seminar, talk with scholars and university and professors, and nobody will know about us. European Union has paid a lot of attention to the cultural advertisement, digital advertisement of their values, but we never did. Maybe since we don't have a unified value, cultural value, maybe we're too much distant in a cultural sense. A fruit from thought. Thank you.
Thank you. Very good remarks. And anyone? Okay.
So, hello everybody. I am not going to ask any questions, just like in name of EUC students, we would like to thank you from our hearts for the chance, for all people or the contribution they provided to us, especially like also unknown solidar like Silvia, Giuseppe, they always did a lot of things. And really, we know a lot of first of all, we know a lot of people from another country. It was good chance for us to discover the cultures and background for everyone from different countries. And what surprised me also, a lot of professors from another country. I'm not going to naming now, but they know a lot of things from our country more than us. So it gives us also space to not to be closed, but always to go and discover other information from other country and try to support. So thanks really everyone. Thanks Ugo. Thanks all professors for this chance. And we would like always to be in contact. Thank you everyone.
Yeah, okay.
Hello everyone. Of course, as my colleague said, it's always a pleasure and it's an honor to be here around you all, around the great professors, and also thanks again to, yes, I will continue. But first, before I say who am I really want to thank you all from deep of my heart, Ugo, Pepe, and all the great professors. I am Rizan Al-Farja, and I'm from Gaza Strip, Palestine. Among the great and incredible interventions from our professors, from our colleagues, everything, of course, has been said is very, very important, but one thing I wanted to stress on, and thank you so much, Professor Nidhi, for even letting me talk, is Gaza. I know all what has been... Many topics have been put today, but one of the most important topics or not only a topic in itself, but it's a life that we should consider and not even forget, is what's happening in Gaza and all of the suffering that is still happening. No matter, even if we look at the recent events, the recent aggressions, the recent conflicts, Gaza remains and still is suffering. Gaza remains under genocide. Gaza remains, under absolute, I really at this point, I am unable to even describe what is actually happening. I do still have family and friends, to the point that when I talk to them, some of them say that we no longer want to live. This world is unfair, inhumane, and on top of all, at some point we continue on with our lives, but Gaza is forgotten. Unfortunately, life goes on, but the problem is that we still need to keep thinking about the people there. We still keep thinking about the possible ways to actually take a quick action to stop whatever is happening there. I know it's easier said than done, but it's not impossible. I know that no matter how much we speak, it will never be enough to actually keep talking on what's happening. I don't want to speak about myself, but I would rather speak of the people who are still suffering, of the people who don't even have the chance to stay in calm and stay in peace the way we are doing here today. We are very blessed, very fortunate to be here today, to be able to speak freely, to be able to not be in fear, while at the same time we're doing this, people are being bombed, killed, starved. Honestly, every single aspect I look at really reminds me that we are so lucky that at the same time we're having all of this, other people are wishing for, dreaming even for. I really saw that all of us were feeling super, super hot today. And this is a very simple thing that we can look at today and we can look at while being in the conference. But people there, they don't even have any source of fan or any source of anything, and they are living in tents where it's very, very hot, regardless of all the other things that are even way more important. But just one thing that we couldn't really handle today is the heat. There it's even way, way worse, and there is no way of even escaping it. For us, we have many options to escape it. We have many options to go somewhere else. We have many options to just lay on bed and not think of anything or even relax after all this. But for them, this is not even an option. This is not even something that they could even think of or dream of at this point. What I really want to say is that it's in our hands. It's really not impossible. It is in our hands to stop what's happening there. We can move, we can do something to stop it. Because even if I keep talking until tomorrow or for a week, I will never be able to tell how badly people are suffering. I will never be able to really address every single point that we might not ever even experience or not even think about. Last night, honestly, there are many things that really make me think of how blessed we are. Last night, on a very random timing, I saw an airplane and it was going to land at Caselle. But to me, that was, when I just heard that there was an airplane, it really reminded me that after this sound, there will be a bomb. But then it didn't happen, and no one even looked at it. I looked around, and I was the only one who looked what that was. And it is to this point that we feel so peace at heart that others, and especially Gazans and many, many actually others, do feel, not only Gaza, but many others. But the problem relies is that it is still going on for almost 2 years now, and it doesn't seem to end because, unfortunately, I can actually say, no matter all the marches, the manifestations, all the attempts to do something, unfortunately, nothing is working. Unfortunately, people are still suffering. Unfortunately, now it has become so normal to see on the news 100 people were killed today or 200 people were killed. This, for everyone, has become just a number on the news, but this, for me and for my people, it's families, it's people we knew, it's our friends, our family members, and I would never wish that any of you even know the feeling, because I don't want you to lose any beloved, but I want to urge every one of you that in any possible way you could take action, please do. In any possible way you could have this in your daily life, please do. If it's either by following the news or even letting other people know, or by boycotting, or by doing any single simple act that could actually help, I do urge you to do that. Thank you so much.
Yeah, okay. It's your turn.
Hi, everyone. Hopefully, after all the urge, let's come back to Brics again. So, ever since the Brics has become Brics Plus, so theoretically, it's not a closed group. My question, or what I think about is that Pakistan, basically, sorry, I couldn't introduce myself. I'm Pulwasha. I was a student of IUC, and I'm basically from Pakistan. So, what I put on the table is that since Brics is not theoretically a closed group, but despite showing interest that Pakistan wants to join Brics, don't you think that Pakistan should be given a chance to join that bloc? Otherwise, the regional power can shift, and in order to create a balance of power in the region, the request of Pakistan should be taken seriously. And one of the main reasons given by the political scientist is that the request of Pakistan is not being accepted because, with due respect, India being one of the main founder of Brics, is that we've been having some tensions ever since we got independence. But the mission and the vision of Brics is to create harmony and promote prosperity, not only in the region, around the globe. So rather than making it a political bloc, why don't we come up with solutions where prosperity can be a right for everyone? Thank you.
Yes. Time is flying. So in the afternoon session, we had a lot of discussion both from the distinguished professors and from our audiences. As one of the organizer of this forum, I just keep in mind several things. Maybe just like one of the audience asked, what is the next step of Brics? Yes, maybe, in the following forum, we will focus on this kind of topic, for example, what's the objectives of Brics, just to move from one hegemony to another, or to just to overturn the international order, or to find a third way to harmonize the existing system and then find a way to protect the rights and interests of the global South, and even just like the people said from Palestine or other, areas. So it's something we should keep in mind as an organizer. And also, according to my record, it's like, the topic related with the data and the digital law. Yeah, it's the new trend of the human society. So we should keep this within our topics in the following forum.
Well, I was not supposed to do the conclusions because Professor Unger was supposed to do the conclusions, but apparently he preferred not to reply to the remarks of Mr. Talha Syed, which is very unfortunate because academia is about having different ideas and defend them. And I would never had expected something like that to happen, because we had honored the man and with deep heart, and we are very grateful of his contribution in life, but really not responding to a critique and not even, saying a few words as it was planned has been quite a surprise to me. So I'm sorry about that, but I think we are in an atmosphere of friends here at the IUC. We like to say things to each other outside of hierarchies, and so I didn't want to pretend that it was my turn to do the conclusions. It was not my turn. Said that, I want to take a few minutes to thank everybody for this beautiful afternoon, and I want to spend at least one moment on the last very touching remarks about Gaza. Be assured that to me, Gaza is not only Gaza, Palestine, and not just now, since I was politically active, which is back in 1975, I think, I became aware of the political conditions on the world. I've always been on the side of the oppressed. I've always been on the side of Palestine. I always thought that it was a large scandal for the Western world to have something like Israel and the West Bank conditions kept in order, in spite of international law, in spite of 80+ declarations of the United Nations, that is the indictment to Western civilization, that Western civilization is not a civilization anymore. See, so that's a point that I have clear in mind. Said that, how to connect this with the Brics? I was in a few BRIC countries in my life, not all of them, but I plan to visit all of them at some point. And I believe that it is very important to learn histories from history. And so we learned the history, and today we talked. I'm very grateful to Mr. Avi Singh and others who took on the non-aligned movement as an ancestor and as an archaeology of what is happening now. That's extremely important. There are 2 points that I want to stress, because one is in reply of Mr. Sasha Stojanović, who actually basically said that it is out of question that China has been a capitalist country. That to me is actually the single most important point by which, at least as a leftist communist, I've been involved in becoming hopeful of the Brics as a project. One thing is that during Cold War confrontation, there was some mirror scandal of one side to the other that were deployed in order to create a synthesis of a dialectic of positions that produced some civilization, some emancipation, and some improvements somewhere. So if the United States were segregating the blacks, the Soviets would point at the United States for segregating the blacks. If the Soviets were putting dissidents into a mental hospital, the United States would point to the Soviet that they would put in dissidents to the mental hospital. And that was a dialectic, was instrumental to a war condition, but was extremely important to create a sense, a generalized sense that some things should not happen, are not acceptable under any circumstances, and therefore countries should be ashamed of what they're doing if they do this kind of things. Okay? So shame is a very, very important factor, or at least has been a very important factor in the development of history. Now, there is no shame about Gaza. There is no shame about Palestine. There is no shame about pointing at people that are criticizing the current condition, slandering them as anti-Semite or other discourses of this kind. This is completely unacceptable under any circumstance whatsoever. And when I was in touch with anybody who was from the Brics area, I made it enormously clear to anyone I had the possibility to talk with that this scandal of Gaza should be the united force behind the Brics reaction. That should be the moment of scandal that produces actually a shift and a transformation in the global moral leadership. Because hegemony is not just about having the soldiers. It's not just about having, the Hollywood industry. It's not just about fabricating the mind of the people to admire some sort of a dream. Hegemony is about persuading even the subaltern that what you are doing is in their interest and is civilized. And what is happening in Gaza shows that capitalism, colonialism, imperialism, and all the new relationships of power between the West and the rest are outside of the possibility of being justified, should be declared bankrupt, and should be substituted. This is what I deeply believe should be the ethos of what we are trying to do here. Of course, we should not be delusional. We are not a political body. We are just a group of scholars that are different from each other, that have some common condition, but we have in mind that we need to reconstruct an alternative to an intellectual moral bankruptcy that is the one in which we are living and of which Gaza is the kind of, so to say, the climax. Okay? So to do that, I don't think it helps, and it helps anybody to say that the 20th century was a century of unchallenged capitalism. Actually, 19th century and 20th century were a century in which there was a sustained, important critique based on moral grounds and not only on political grounds of the scandals of capitalism that were already out there at the time. It's not that we invented capitalism now. Today we just see something with a more horrible face we could imagine, but those relationships of power were out there already. And one of the great efforts to go outside of this was the great proletarian revolution in Russia. Okay? We had a moment in which the betrayal of the popular masses by the bourgeoisie after the French Revolution, which have created reaction, has been capable, at least for a certain period of time in one country, to create a real alternative that was capable to create a dialectic with capitalism. And that alternative we should cherish, because that alternative is still out there in China today. So I refuse frontally any discourse that say China is just another kind of capitalism. Because saying that China is just another kind of capitalism is the end of the hope that the new hegemony might become a socialist hegemony. And for someone who is a socialist, that is the point in which you stop having any hope in what transformation can become. Now, of course, socialism today is not, the Chinese socialism today is not the kind of socialism that was out there in 1917, of course, but there are certain kind of things that from the leadership of China within the Brics we can take home in order to create some vision for the future that, of course, we cannot elaborate here, but we can facilitate by deploying and offering certain kind of tools that are the tools of knowledge and that are the tools of past experiences that we can to update for the present. And this is what, taking an approach to law as comparative law is about. It is not true that we have not talked about law here. I don't know who said, there is not enough discussion about law. There is some discussion about law, but we need to understand the basics first. We cannot approach something as foreign and complex, something that was so much marginalized for a lot of time, something that was so much denied, even the nature of legality. You know how many times you said, China lacks the rule of law. Why China lacks the rule of law? Oh yes, because they have Li and they have Fa, Li is more than law, Fa is less than law, therefore they don't have the rule of law. This is the level of Western discourse, leading Western discourse about China. Okay? So this kind of platitudes should not be respected in academic settings. Period. No matter whether they come from Harvard, from Yale, from Chicago, or from where they come from. If they are platitudes lacking any meaning outside of outright propaganda for the dominant power, we should have the courage, to reject them. To say, this is not what we are talking about. We are trying to reconstruct law in its own terms, taking in full consideration its history, its political relationships, its class structures, its shortcomings, whatever, but its historicity, which is nothing that we are creating here. We are not inventing Brics law. We are trying to understand and ascertain what are the material legal conditions that makes law law, as Talha was saying before. This is what we are doing here. And we are in front of a scenario in which many people don't know much about the law in any of these countries, nor this country know enough about each other. And this, I think, is the kind of gap and the kind of lack that opens some opportunities for academia or for going in a certain kind of research direction and for calling for a research hypothesis that goes in a different direction. To me, however, it is important to say very clearly that the main reason why Brics is becoming interesting is that there is a shift of global economic power in favor of a socialist country. This is what is happening. Okay? Now, we can deny and we can discuss the nature of socialism in China. We can discuss whether that kind of a socialist idea can be expanded and understood elsewhere, can become actually the backbone of something different. We can discuss all of that, and I hope we will do, but I don't want to see this enterprise in becoming some technical forum in which we discuss, mortgage without dispossession in trust law or stuff like that. This is not what I'm interested in. I'm interested in something very important, taking home one lesson, which is that we are today in a condition of crisis, I already said, Gaza, but not only. Golnoosh talked about the disaster of the ecological catastrophe, the question of water. You know that when the bombing of Iran started last week, the real estate market in Dubai plummeted 20% in one day. Why? Because there was the risk of water pollution. As simple as that. This is one disaster, and it's out there. There is the moral disaster of Gaza. It is out there. There is, however, a technological transition, which can be a disaster, cannot be a disaster, we don't know. It is a disaster from the point of view of consumption of resources, maybe. Are we talking about countries in the Brics that are deploying less than clean ways to produce energy? Maybe. However, I must say that there is a lot of greenwashing and green propaganda going on in the West today just to favor the financial complex that is shifting the production of energy away from certain places in the world into others with no clear understanding whether that is good or bad in a systemic perspective. So there is a lot to study in many areas, including energy law. Now, I think that one thing that socialism, and I want to call it socialism, carries to us is the idea of the plan. The idea that we can plan something. We can imagine a point of arrival and we can move steps in the direction of reaching that point of arrival, provided we have enough information on the behavior of the single actors. Planning is the big loser of neoliberalism. Neoliberalism is about destroying any possibility of planning, as if planning was some sort of Soviet obsolete KGB structure of bureaucracy. Planning is something that today, with the capacity we have to collect data, is becoming entirely possible. And it's a matter of understanding how you can make planning with some kind of an institutional setting that is capable to give control not just to the elite, but to the people. That is the great question of socialism. How do you give control to the popular masses? How you use the popular masses and you deploy their needs and their desires of transformation in the direction of something that is a society that is more fair and more just. Okay? We've been doing that or trying to do that for a long period of time. We will keep doing that. I think that planning and technology are the two things that we have to study and to understand, because you see, in the West now we have developed some sort of phobia about the technological transformations that are occurring now, either, or not even a phobia, like, some sort of hooligan's attitude. The super pro-technology, guys that believe that innovation, technological innovation is going to be the solution of everything, and the paranoid on the other side that think, oh, no, they are controlling me even when I'm in the toilet in the morning taking care of my own affairs. Now, this is not serious. This is not serious. Technology is the outcome of the way in which capital is organized, where we put the money for the infrastructure, where we get the money of the infrastructure. This is what technology is about. And those are the places where choices can be made. But these choices have to be informed and not paranoid of each other. I think that in the future of this enterprise we are starting, we will find topics that are of importance, maintaining some sort of, big picture attitude, but also I think we should point out the points of rupture in which a world with a hegemony outside of short-termism and market fundamentalism should go. And I think that the capacity and the possibility to plan in the current condition, which incidentally are a living denial and critique of whatever Hayek and the neoliberal talked about, is a great opportunity. We should seize this opportunity and we should work hard in that direction. Said that, I thank you very, very much for being here. I think it was a very successful exchange of ideas, and I love you all, and I hope we will have a good. Thank you. Thank you.